In a criminal case, a confession feels like the ultimate proof, right? The smoking gun. But what happens when that very confession is, well, questionable? Today, we're going to dive into a landmark case that forced the entire legal system to wrestle with that exact problem.
I mean, it sounds kind of weird, doesn't it? When is a confession not a confession? You'd think an admission of guilt is, well, the end of the story, case closed. But what if it's not? What if the confession itself is the most complicated part of the whole puzzle? Let's dig into a real-life case where that's exactly what happened.
All right, so our story starts in a small town, a place completely gripped by fear because of a series of arsons. And the main suspect? Well, let's just say it was someone nobody saw coming. So picture this. It's the mid-90s in this tiny community, Waterville, Nova Scotia. And for about a year, they're just living on edge. 8 different fires. 8, lighting up the night, hitting buildings, cars. You could just imagine the fear. Everyone's asking the same questions. Who's doing this? And are we next? So the police start their investigation. They're looking at people, and one name keeps popping up. Richard Oickle. Now here's the kicker, the absolute irony of it all. Oickle was a volunteer firefighter. Yeah, the guy whose job it was to rush to the flames was the one they suspected of lighting the match. Okay, so to figure this out, the police bring Oickle in for a quote-unquote voluntary lie detector test. It starts at 3 in the afternoon, but this thing just spirals. At 5 p.m., they tell him he's failed the test, and that's when the real questioning begins. 2 hours later, around 7 p.m., he cracks. He confesses to setting his fiancée's car on fire. The police notes even say he's emotionally distraught. But they don't stop. They take him to the police station, keep up the pressure, and by 11 o'clock at night, he's confessed to 7 of the 8 fires. And get this, after less than 3 hours of sleep in a cell, they wake him up at 6 a.m. to go and videotape a reenactment of everything. And somewhere in that long, exhausting night, Oickle says something that becomes absolutely central to this whole case. He asks, what if I admit to the car? Then I can walk out of here and it's over. And that right there, that's the core of the problem. Was this a genuine confession, or was he just saying whatever it took to make it all stop? And that one question, it changed everything. Suddenly, the courts had to look past the confession itself and focus on a much bigger issue. How did the police get it? So this is where things get really, really messy, because you can look at the police tactics in 2 completely different ways. On one hand, the police said they were just being smart interrogators, acting friendly to build trust, offering psychiatric help, downplaying how serious the crimes were. But on the other hand, Oickle's lawyers saw something much darker. They said the police abused that trust, that the offer of help was basically a bribe for a confession, that they misled him about what would happen, and, this is a big one, that they used the threat of questioning his fiancée to turn up the heat. And believe me, this was not an easy call. Even when the case went all the way to the Supreme Court of Canada, the judges were split. Justice Arbour wrote this really powerful dissent. She basically said, look, you have to look at everything together. The subtle promises, the threats about his fiancée, this whole oppressive feeling created by the infallible polygraph. She argued that all of it combined was enough to completely overwhelm the free will of the accused. In her eyes, the confession was worthless. So you've got this major disagreement at the highest court in the country. That's a huge red flag. The Supreme Court realized they couldn't just rule on this one case. They needed to create a set of rules, a clear roadmap for every judge in the future to follow when they're looking at a confession. And that's exactly what the majority did. They created a landmark framework that's now known as the Oickle's test. It's a standard designed to make sure that a confession, which is, let's be honest, probably the most powerful evidence you can have, is truly voluntary before it's allowed in a courtroom. This test is built around 4 big questions. 1. Were there any threats or promises? 2. Was the situation oppressive? 3. Did the suspect have an operating mind? Basically, did they know what they were doing? And 4. Did the police use any dirty tricks that were so bad that they'd shock the community? So let's walk through how the court applied these 4 ideas to Oickle's case. All right, first up, threats or promises. The court was looking for what lawyers call a quid pro quo, a this for that kind of deal. And yeah, the cops offered psychiatric help. They even hinted his fiancée might be spared some questioning if he talked. But, and this is a really fine point, the court's majority said they never explicitly connected the 2.
They never said confess and then you'll get help. Because there was no direct bargain, it passed this part of the test. Okay, number 2, oppression. Basically, were the conditions just unbearable? Look, the court agreed the interrogation was long and Oickle was exhausted, no question, but they pointed out the police were polite. They weren't yelling or being aggressive, they offered him food and water. So even though it was really tough, the court decided it didn't cross the line into being legally oppressive. Third factor, operating mind. This one's pretty straightforward. Was the person in a state to understand what they were saying and that it was serious? The court looked at the evidence and decided that, yeah, even though he was exhausted and upset, Oickle was coherent. He knew what he was saying and that it would be used against him. And finally, that brings us to maybe the most interesting part, police trickery. I mean, let's be real. The police absolutely deceived Oickle. They totally bluffed about how accurate the lie detector was to back him into a corner. But here's the thing, the court set the bar for this incredibly high. The trickery has to be so bad that it would shock the community. And in this case, the court decided that, well, police bluffing about evidence just doesn't meet that crazy high standard. It's considered a legitimate tactic. So, after going through all 4 of those factors, the court was ready. They made their decision, and it was a big one. A decision that would shape Canadian law for years and years to come. The final verdict? The Supreme Court decided that Richard Oickle's confession was voluntary. They reversed the earlier decision from the Court of Appeal, which means his conviction for arson was put back in place. So why are we still talking about this case today? Well, because the Oickle test it created is now the rule book for this stuff in Canada. It's this constant balancing act, right? On one side, you have to protect people's rights from being violated. But on the other, you have to let police do their jobs, which sometimes includes using psychology to get to the truth. The whole point of the test is to try and find that balance, and most importantly, to stop the justice system's absolute worst fear from coming true, convicting an innocent person. But even with this test, the case leaves us with this big, nagging question. In the intense pressure of that interrogation room, where do you draw the line? What's the difference between a clever interview that gets to the truth and psychological pressure that just creates a confession? The court drew a line in the sand with this case, but people are still arguing today about whether they drew it in the right spot.